Hey there, Legal Tea listeners. This is your host, Jenny Roselle. We're back to Estate Planning of the Rich and Famous, where we chat about celebrities and their estate planning. Today's episode is on Robin Williams. And I tell you what, Robin Williams is one of my favorite actors. It's probably because I love the movie Mrs. Doubtfire, and I probably quote that movie at least once a week. Anyway, as we do on these episodes, let's talk about Robin first, kind of his life, his family, before we shift into what happened estate-wise following his passing. Let's kick things off by chatting about Robin and those closest to him. According to his Wikipedia page, Robin married his first wife, Valerie, in June of 1978, and together they had a son, Zachary, who was born in 1983. A few years later, in 1988, Robin and Valerie divorced, and shortly after that divorce, Robin began a relationship with Zachary's nanny, Marcia, and the two ended up getting married in 1989. At the time of their marriage, Marcia was 6 months pregnant with their child, who ended up being named Zelda. And a couple years later, the couple had a third child, Cody, in 1991. Nearly a decade later, the couple did end up divorcing in 2010, and the following year, in 2011, Robin met and ended up marrying a third woman, Susan Schneider. Tragically, on August 11th, 2014, Robin Williams passed away by suicide at the age of 63. Even though there had been reports that Robin had a former drug addiction and alcohol addiction, drugs nor alcohol were discovered in his body at his passing. According to CNN, Robin's publicist, Mara, shared that Robin was experiencing severe depression before his death. And also, according to CNN, Robin's wife, Susan, also shared that while it had not been publicly revealed, Robin had been diagnosed with early stages of Parkinson's disease, with hints of Lewy body as well. Lewy body dementia, that is. In fact, according to an essay written by Susan, she shared that Robin's condition was, quote, described by several doctors as among the worst pathologies they had seen, end quote. Following Robin's passing, it was discovered that he actually had an estate plan, so at least he had something. In all of these episodes that I've done over the course of Legal Tea podcasts, there have been quite a few where the person had no estate plan at all, right? So at least Robin does not fall into that category. According to an article by the law firm Trust Counsel, an estate planning law firm in Florida, Robin had created a living trust, or perhaps a couple of trusts, and that shortly after Robin and Susan married, Robin amended the trust. At Robin's passing, the trust contained the following specific wishes. First, Susan could continue to reside in their home in Tiburon, California. Second, the Napa Valley house and its contents were to go to his children. Third, the furniture, furnishings, and some of the contents of the Tiburon house was to go to Susan. Fourth, all of Robin's clothing, jewelry, and personal photos taken prior to his marriage to Susan, as well as memorabilia and awards from the entertainment industry, were to go to his children. And fifth, finally, the trust stated that the rest of the contents that were not specifically provided for in the Tiburon house were to go to Susan. So one would think that that's nice and specific, right? Well, clearly it was not specific enough. According to the article by Trust Counsel, Susan ended up filing with the court to gain clarification on what some terms in the trust actually meant. So, for example, Susan argued that the word memorabilia should mean only specific items of personal property as it related to Robin's acting career. Furthermore, she also claimed that the term jewelry should actually not include his collection of watches. There were a few other things that Susan wanted clarification on from the court that I won't bore you with, but the takeaway here is that it was all about tangible personal property. And you know, a lot of families and beneficiaries fight about money. We all know that. But this was primarily about tangible stuff. And on the surface, it looks like Robin put some significant thought about like what went to who. So interestingly, a couple it was a long time ago, maybe around Thanksgiving a couple years ago. Anyway, we talked about blended families and how their estate planning can kind of take a sharp left turn super fast. Well, here is an example of that. It's just with the celebrity involved. According to Trust Council's article, part of Robin's trust included a provision to have the trustee, the manager of the trust, take a chunk of change to cover all costs related to the residence and have the trustee cover the expenses for the Tiburon house that Susan had a right to reside in. Now, I believe I read somewhere that the trustees were Robin's estate planning attorney and accountant. And part of Susan's claim was asking for the trustees to utilize trust funds to cover around $30,000 in renovations. Now, the trust was super not specific. All it said was, quote, all costs related to the residence. So, like, are we talking about utilities, property taxes, and upkeep? Or if, like Susan here, wants to make major renovations, did Robin intend to allow Susan to pull those strings too? Who knows? We'll never know. But it was so non-specific that Susan did have a leg to stand on to request court clarification. Now, according to an article written by Goralka Law Firm in California, Robin's children, when responding to Susan's attempts for clarification of those trust terms, they stated that they were, quote, heartbroken that Susan has acted against their father's wishes by challenging the plans he so carefully made for his estate, end quote. An article written by Kevin Hunt in the a Hartford newspaper, the court seemed to not be having this kind of back and forth and finger pointing. And in fact, the judge, following Susan's petition, gave Susan and as well as Robin's kids a whopping 2 months to kind of figure stuff out, or more eloquently, as Kevin writes, to resolve the dispute themselves. I feel like I read somewhere that things did end up getting settled or they reached a settlement. So full-blown litigation at least did not occur. Honestly, probably thanks to the judge saying, you guys need to figure this out. What I find particularly interesting about Robin's estate is that Susan and Robin's kids were not really fighting about money, right? You know, so often people in my estate world fight over money and property like a house. But here it was solely about tangible property. And of course, tangible property has a value. But it's not super often that estate litigation happens only because of tangible property. But that's what happened here. I have to wonder if the primary issue was that it was a blended family. Susan was not Robin's, kids' mom. And Susan keeping some of Robin's stuff may just have rubbed the kids the wrong way. And I suppose what I'm saying here is that if Susan was the kids' biological mom, we may not have even seen this fight happen. As I was writing this episode, I actually, kind of crazy enough, had met with a prospective client, and it was a blended family. The husband has 2 kids, not with the wife, and the wife has 2 kids, not with the husband. And prior to our meeting, they sent over a laundry list of tangible property items that they wanted to include in their will to ensure that there were no fights between the kids. And I just had to share that on this podcast. It was just really timely with that happening and writing this episode on Robin Williams and what happened with his wife Susan and Robin's kids, and how they were all mad at each other and duking it out over personal property. The wife, talking about my client, not Robin's wife, the wife jokingly actually kind of slapped the husband on the arm and said, "See?" And it kind of gave me a laugh because I think they thought it was embarrassing to be so particular or something about this personal property. But as I shared with them, I found that, many times families fight over money, like I said, but money, money on the table brings out the weird in people. But often when there are unique relationships, like in a blended family sometimes, and a death occurs, emotions are already extra high. And then when you have to start wondering, oh, was my stepmom going to get my dad's guns or, dad's watches or dad's classic car? What if she keeps them and gives them to her kids? The audacity. let me tell you, it's no longer about the money. It's about making a point at that point and being right and doing what dad would have wanted. And that's when I start hearing all of those sentences getting thrown around. So let's talk about how we can prevent all this craziness. First, you really should spell things out specifically and intentionally, especially if you think that there could be disagreements about tangible property. There are two ways that you can spell it out, guys. First, you can either incorporate the verbiage into your will or trust, meaning the provisions would be like inside the document. Or second, you can have your will or trust reference a document like a memorandum of personal property, which becomes kind of a freestanding document that references specific items to specific people. Honestly, the latter is easier to change and keep updated, but the first option of like putting things actually in the document, while it would require you to update the actual will or trust through an amendment, it would stand a little bit, it's a little stronger, I guess, is the way to say that. Another tip along this kind of spell it out topic is if you want to help your executor or trustee, you could take pictures and make sure wherever your provisions go, whether it's in the document or in a memorandum, that the provisions reference those pictures. I have several clients that have taken pictures of items and even given me a flash drive of the pictures as kind of like a backup copy. Second, if you take the route of doing the memorandum, if you want to be able to keep it updated a little easier, make sure your attorney always has the latest version of that memorandum. And that way, if you pass away, the memorandum, if it just so happens to accidentally, or wink, wink, not accidentally at all, disappears, your attorney will have the latest version, so long as you provide the latest version to the attorney. Lastly, it certainly does not hurt to have conversations about what goes to who with your beneficiaries once you figure out where things are going. I have to wonder if Robin Williams, had he sat his wife, Susan, down and sat his kids down to say like, okay, this is what I want to have happen. Maybe at that time, Susan and his kids could have clarified a few things that ultimately maybe would have resulted in the court not getting involved. So like, for example, like the whole piece about whether watches equals jewelry. Maybe Susan would have asked Robin in that moment, hey, are you thinking that watches count as jewelry? And that could have been the end of that. So I'm always an advocate for having these kind of tough conversations. As much as people don't want to talk about this estate stuff, I will never understand why more people do not talk about it with their family and beneficiaries. Alrighty, let's wrap this episode up and shift to a sneak peek at next week. Next week, we're back to a cautionary tale episode where we talk about real life clients, real life cases that I or my office have worked on. Or maybe they are just generally good things to know and be aware of so that you do not slip up and turn into a cautionary tale one day. During that episode, we're going to dive into estate planning specifically for farmers and the types of unique challenges and decisions that, they have to kind of deal with and decide on and that they have to face from an estate planning perspective. So tune in next week for that. And until then, Legal Tea listeners, take care and be well.